Why is dying intestate so complicated for heirs? Imagine losing someone you love and then facing a maze of legal rules that decide who gets what. When someone dies without a valid will, things can get really tangled for the people left behind. This situation is called dying intestate, and it often leads to confusion and disagreements. The main reason is that state laws take over and decide how assets are divided. These laws follow a set order, giving priority to spouses, children, parents, and then other relatives. But these rules might not match what the person who died actually wanted. For example, if someone was in a long-term relationship but was not married, their partner might not get anything under intestate laws. Or if a person had a blended family, the laws might not recognize all the relationships the way the person intended. Another complication is the appointment of someone to handle the estate. Without a will naming an executor, the court chooses someone to manage the assets. This person might not be the one the deceased trusted or wanted. If family members disagree about who should be in charge, the process can slow down a lot. It can take months or even years to settle everything. Before any assets can be handed out, all debts and bills of the deceased must be paid. This can include mortgages, credit cards, or taxes. Sometimes, the estate's value shrinks because of these debts, and heirs might not get what they expected. Disputes can also happen over which debts are valid or how they should be paid. Legal fights among heirs are common when there is no clear will. People may argue over who should get what or how assets are valued. These disputes can drag out the process and cost a lot of money. Family relationships can become strained or broken because of disagreements. When the person who died has minor children or relatives with disabilities, the situation becomes even more complicated. The court must appoint guardians or conservators to manage their inheritance. Without proper planning, these heirs might receive assets too early or lose access to public benefits they relying on. Special trusts are often used to protect vulnerable heirs, but setting these up requires a will or estate plan. The emotional toll on families can be heavy. Uncertainty and disputes create stress and resentment that can last for years. Without clear instructions, families often face long, costly legal battles that could have been avoided. From an elder law perspective, having a will or trust makes a big difference. It allows people to specify who gets what, name trusted managers, and set up protections for minors or disabled heirs. Proper planning helps avoid the delays, disputes, and emotional pain that come with dying intestate. It's a way to make sure your wishes are followed and your loved ones are cared for.